I don't know that I could say I'm going to do this after a hearing because she is highly inebriated. She's a .224.
Right from the opening seconds, Judge Simpson sets a tone that immediately tells us this case is already off the rails. When a judge openly questions whether a hearing can even proceed because a party is highly inebriated, that is not normal courtroom business. That is damage control mode. The court isn't reacting to a legal technicality yet, it's reacting to basic capacity. Courts require parties to be sober enough to understand proceedings, answer questions accurately, and make legally binding statements. If someone cannot do that, anything said on the record becomes questionable, and that risks appeals, reversals, or claims of unfairness later. What makes this more dramatic is that this isn't just about intoxication, it's about credibility. The judge is already weighing whether anything said today can be trusted. Add to that the mention of the sex offender registry and the address issue, and suddenly this case isn't just messy, it's potentially dangerous. Housing cases tied to registry compliance are taken extremely seriously because they implicate public safety, not just private disputes.
Court recalls the case of New Parker Apartments versus Tubbs.
Same for the plaintiff, Your Honor. Our decision to wait for Ms. Stubbs paid off. She's here.
State your name.
Sherry Tubbs.
Okay. Where are we on this case? And then I have a question.
There.
Goodness. I usually don't bring
This
my
is the
comments.
worst thing that happens today.
I know, I never do that. I'm sorry. I never have my.
The sex offender registry still shows Mr. Gardner is living there. There's I found in there somewhere where it looks like there was some check made on 8/27 of 25, so in August of this year. I don't know what it means. I'm not saying that that means they confirmed it, but there's a date in August of 25 in the sex offender registry records. And I did a Lexus person search, and apparently his driver's license is at her address still. She acknowledges that it has not been changed. I given Officer Allen a default judgment. I think it could now be after hearing, and she says she wants to try to get this done. And so if the court gives her more than the 10 days.
Yes, because he had went to the post office and changed all his mail, which last time I was here, I didn't know.
Ms. Tubbs, Ms. Tubbs, before you go on, have you been drinking?
This exchange is where the courtroom shifts from uncomfortable to openly chaotic. Judges rarely ask questions like this unless they already suspect the answer. And when Ms. Tubbs immediately admits to drinking, the legal problem becomes unavoidable. Court isn't just a place to show up. It's a place where your words carry legal weight. If you're intoxicated, the judge has an obligation to step in, not to punish, but to prevent an invalid hearing. What's striking here is how the answers unravel. A couple of beers turns into 18 or 24 ounces, then drinking at 2 or 3 in the morning, then admitting this is routine behavior. From a legal standpoint, this isn't about morality, it's about reliability. Judges listen for consistency. Every contradiction chips away at credibility. When a party minimizes their drinking and then corrects themselves repeatedly, the court starts assuming the truth is worse than what's being admitted.
Yes, I have a couple of beers, yes.
How much did you have?
I drink beer.
Okay, so how many beers did you have?
18 ounce or 24 ounce, yes. I would.
Yeah, that's the nice thing about the 24 ounce. You can say I only had 2 or 3 beers.
So this morning, can you get Teresa down here with the PPT, please?
I will say like 2 or 3 or 4 o'clock in the morning. Because that's what
2 or 3 o'clock in the morning you started drinking?
That's what time I usually get up and drink milk beer.
Okay, so how many did you have this morning?
A beer.
Just one? One, what, 24 ounce?
24. I will acknowledge that, yes.
So that's like 2, but what kind,
I don't know how much come into 24 ounce.
24 ounces. What kind?
Bud Light.
Oh, of course. Bud Light. Why did I
Yeah,
ask?
I drink Bud Light. I used to drink Miller High Life, but I drink Bud Light. I used to drink a lot of liquor, but Bud Light. Why would you ask me that?
Because I've got to determine whether or not you can adequately do this hearing. Mr.
Oh,
Allen,
yeah, Your Honor.
Mr. Allen,
I,
I'm going to give you a PBT.
what is that?
Okay. That's a preliminary breath test.
The decision to administer a PBT, a preliminary breath test, is a turning point. This is no longer casual questioning, it's verification. Judges do not rely solely on self-reporting when sobriety is in doubt. A PBT gives an objective snapshot, not for criminal prosecution here, but for courtroom management. The court needs a measurable answer to one question. Can this person meaningfully participate right now? What's important is what the judge does not do. He doesn't scold, threaten, or embarrass her. He calmly explains the process and pauses the hearing. That restraint matters. If a judge appears punitive in this situation, it can look like bias. Instead, Judge Simpson keeps the record clean by focusing on procedure. The brief humor and nervous energy in the room during her exit underlines something deeper. Everyone knows this case is spiraling, but no one wants to be the one who pushes it into outright disaster. When the judge says, "Watch your step," it's literal and symbolic. The court is walking a line between compassion and control.
Oh, okay.
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 So here's what's going to happen. You're going to go back with Mr. Allen, and there's going to be a PBT. You just need to blow into the machine, and then we're going to see. Okay? Thank you, Miss Tubbs. Watch your step. Okay, bye-bye. I know. Glad that's what came out of her mouth. All right. You know, there are times in life where I'm just afraid to call another case. just kind of take a pause and you just hope.
Hey.
Are they
They're doing what they do.
okay?
Some people wake up in a number that would send other people to bed.
I know. You know, I was just gonna ask for breakfast, really? I don't think. Off the record? No, I'm gonna say what I gotta say. Because
Okay. Right. Whoa, whoa, whoa. Whoa, 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 whoa.
Who's getting that to whom?
I'm not really sure, but I'm afraid to go back and look. Is Mr. Lloyd, is yours simple? Where'd Lacey go?
Very fast.
Oh.
That's what Magnus said. And then no. Okay. Corey Goff.
We heard you.
Oh, holy. Okay. Hold on a second. Miss. Okay, Miss Tubbs.
Uh-huh.
Okay.
Yeah, I already know. I was drinking last night too.
When Miss Tubbs returns, the tone changes again, not because the facts improved, but because the truth finally surfaces. She admits to drinking the night before as well. From a legal perspective, this confirms the judge's earlier concern. This was never just one beer. The court now has a pattern, not an isolated lapse. The judge's question, "How did you get here?" is deceptively important. Transportation answers whether there's an immediate public safety issue. Had she driven herself, this case could have exploded into something criminal beyond the housing matter. The relief in the judge's response, "That's probably a good thing," is real. This exchange also shows judicial triage. The judge isn't trying to fix her life or address addiction. He's narrowing the scope back to the courtroom. Can we proceed safely? Can we proceed fairly? The answer, increasingly, is no. Audience question: should courts be stricter about sobriety at the door, or does that risk denying people access to justice?
Yeah.
I already know what it was gonna be, Miss, Simpson.
Uh-huh. Okay, so let me first ask you this, and then I'll try to see what we're gonna do with your case. How'd you get here?
I got dropped off by my sister.
You didn't drive.
No, I don't drive.
That's probably a good
I don't
thing.
have a license, so I don't drive. I know how to.
That doesn't stop everybody,
And I'm
but
getting on the bus when I.
okay, so Mr. Fink, I don't know that I could say I'm going to do this after a hearing because she is highly inebriated. She's a .224.
What does that mean?
It means you are seriously.
That's probably about 3 sheets to the wind. Never mind. You don't know what, off of one beer? No, you had more than one.
This is the moment where credibility fully collapses. The phrase 3 sheets to the wind may sound casual, but it's devastating in court terms. It's the judge openly acknowledging visible intoxication. When Miss Tubbs pushes back, insisting it was only 1 beer, the contradiction is immediate and damaging. Courts remember inconsistencies far longer than apologies. Her admission about playing a drinking game the night before seals it. At that point, the judge isn't deciding guilt or innocence. He's deciding whether this hearing has any legal value today. And the answer is clear. Any ruling made now could be challenged later as unfair or invalid. This also reframes the earlier registry and address issues. Those questions don't go away. They're simply postponed. The judge is effectively saying, this is serious and it deserves a sober courtroom. That protects both sides and preserves the integrity of the system. Emotionally, this is hard to watch. You can hear someone trying to salvage their case while sinking it further with each explanation.
Okay, I played a drinking game too, so that was it. Oh, man, did I say that? I'm sorry. I know play the drinking game.
But that wasn't beer, right?
That was,
You were just talking about beer before.
yeah, I did
You
have
were lying.
a beer at 3 o'clock or something in the morning, but I did play the drinking game the night before.
You
So,
told the truth. And
And
nothing
then,
but
not
the
the
truth,
truth,
but
but
not
I didn't tell the truth, whole truth. Joe Simpson, I didn't tell the whole truth, because I played a drinking game like. I played a drink game.
Your Honor, the efficient thing to do would be to come back on Friday with a regular landlord-tenant docket.
yes, it would.
The kind thing to do would be to maybe come back the next Friday so she can have one more shot at trying to get him to the state police and get it to.
No, but the state police is way out in, right now have
You
transportation.
don't have to go there. Willie Gardner's gotta take care of this, or you're gonna get
Oh.
put out. And everybody's-
Oh, he had to,
Everybody's trying to
believe
save
it.
Tennessee.
I'm just
You need to
walking
get on the team with us.
oh,
So how about
come on, Mr. Simpson.
26, Your Honor?
Come on, what?
Judge Simpson, I do not need to be paid. I ain't had a permit in 15 years, and I finally got my own permit. I know this was a sex offender, none of that stuff.
Okay, so
But when I come back, I'm gonna be
Just
here.
on the regular docket
On
on
the-
26.
on the 26th. Okay, so here's what I'm gonna do. All right, I'm going to adjourn this, and it's gonna go back to basically a pretrial for September 26th, 2025 at 3 p.m. That's in the afternoon.
Adjournment here is not mercy alone, it's strategy. By pushing the case to a later date, Judge Simpson resets the playing field. Everyone gets notice, expectations are clear, and sobriety becomes a condition, not a suggestion. This prevents future excuses. The judge also explains consequences plainly. If compliance isn't handled, eviction becomes real. That clarity matters. Courts often give one final chance, but they document it carefully. From this point forward, Ms. Tubbs cannot claim confusion. The record shows warnings, timelines, and expectations. Her emotional response about grandchildren humanizes the case. But notice how the judge redirects. He acknowledges her stress but refuses to let emotion replace responsibility. That balance is judicial professionalism. Sympathy does not override legal duty. Audience question: do you think this adjournment helps her or simply delays the inevitable?
Oh, yeah.
Okay,
So
so,
I'm gonna drink at 3 a.m. I'm just playing. I'm just playing.
okay, I just, Ms. Tubbs, Ms. Tubbs,
I appreciate you, Judge. I really do.
Ms. Tubbs.
Just not every bit of our first.
I know, but Ms. Tubbs, here's, okay, I'm giving you basically 10 days to sober up. And get that,
Right today. I'm not drinking no more today. I promise. I ain't gonna drink no more till the 27th. I'm just saying. I just try to keep our apartment.
I know, so I'm not,
Two grandkids, and
Okay.
they left come to my apartment.
okay, I'm not gonna get into that. All I need,
31 grandkids, 10 kids, 31 grandkids.
31,
31 grandkids, 10 kids, 5 boys, 5 girls. And they love coming to my apartment, just, they don't live with me, but they just like to come and play.
okay, so here's the deal. I'm gonna adjourn it out to the 26th at 3. Next time you walk into my courtroom, you need to be sober.
Promise. I got a Bible in my purse.
No, let's not do that. All right.
Bible in my purse. Look him up. Thank you, Judge.
Yep, you take care.
I am.
Okay,
Thank
you
you so much.
go ahead and you just be safe out there, okay?
I'm gonna get on the bus. I just ride. Thank
You're welcome.
you.
Yeah, no, we're not. No, we're not laughing at you.
Thank you.
Yes, yes. How much you want to bet it's the wrong bus?
Any excuse?
Yes. Thank you, Mr. Fink. You know, I'm gonna keep calling cases because it can't get any worse. Field Properties versus Jason Mitchell.
This final exchange sums up the entire case in one sentence. Sobriety is the entry fee to justice. Judge Simpson doesn't lecture, moralize, or threaten. He draws a boundary. Come back sober, or the system will move forward without you. Legally, this case ends today without a ruling, but not without consequences. Ms. Tubbs has been given time, notice, and a clear warning. If she fails to comply, the court will likely proceed quickly next time. The broader implication is simple. Courts can be compassionate, but they cannot operate in chaos. For viewers, this case is a reminder that showing up is not enough. How you show up matters. Credibility, consistency, and respect for the process determine outcomes just as much as facts do. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.